I don't know whether you have studied about the property law, hukum kebendaan in Indonesia. I assume you have, because there is part of the civil law. Hukum perdata, you are studying contract law, of course, after you study and understand civil law in general. So we can see that the law of property has a closed system, while the agreement law adheres to an open system. So there is the law regulating about the agreement. In the first session, we discussed that an agreement causes obligation, to rise. Perjanjian menimbulkan perikatan, right? There is also another source, which is the law, the law and legal action according to law and legal action violating the law. We learned about zakwaarneming, and also we learn about perbuatan melawan hukum, unlawful act. Now that is under the obligation, so perikatan. The agreement law is an open system. That is the main theme of this session. Whether the law of property or the property law, well, when I'm talking about property, I'm not talking about real estate, or real property, which consists of only land and building. When I talk about property law, I talk about all types of property. So anything that can be owned and can be used and then can be rented or can be sold by anyone. So benda, we understand the concept of benda. We call it hukum benda or hukum kebendaan. And after we talk about property law, we also have a property right concept, hak kebendaan. When we talk about agreement law, hukum perjanjian, we also have a concept of relative right, hak relatif or individual right, hak perseorangan. The legal concept is different, the execution is different, how to file a claim against the other party with regards to the individual right or with regards to the property law is also different. So the law of property has a closed system. So it means that it's not opened where the parties can deviate from it. It's a closed system. So you have to comply with it. That's the end of the story. This is the law. When you have a property, this is the law. This is what you can do about it. This is what you cannot do about it. How is it transferred? It is regulated. How you protect your property is also there. So everything related to the property and property law is a closed system, meaning it's coercive. It's like hukum memaksa. So you just have to comply with it. You cannot negate or you cannot deviate from what is regulated under the property law. While the agreement law is in contrast to it. It adopts an open system. So open system means that it's not very rigid. It is more flexible. That is why it's called open. The parties can agree otherwise. The parties can deviate from the provisions under agreement law. What is meant by closed system is the various rights to objects are limited, and the regulations regarding the rights to objects are coercive. Of course, when we are talking about closed system, they define clearly what is considered as property. If we look into a hak atas tanah, for example, land right, there is part of hak kebendaan, there is part of the property law. Yeah, they define clearly what is considered as hak milik. They define clearly what is considered as hak guna bangunan, hak guna usaha, and so forth. So all provisions, all regulations under property law are coercive type. Yeah, you cannot negate it. You cannot give other definition than what has been defined under the law. Yeah, hak milik has been defined, for example, but then you define it differently. Yeah, hak milik, we have it, the hak milik concept under the land law, but we also have it a similar concept under the property law, hak milik, right? You can see it in the part of hukum benda, bagian benda under the ICC, what is considered as benda, yeah, and what is considered as memiliki benda, yeah, owning that property. So one is closed, one is opened. So agreement law gives the broadest freedom to the people to make any agreement unless it does not violate public order and decency. Also, it does not violate the law itself. So of course, it's not open as far as possible without limitation. We will look later that there are some limitations. Yeah, even though it is an open system, the parties are agree to stipulate otherwise from what has been regulated under the Indonesian Civil Code, but it does not mean that it is without limitation. Yeah, of course, every principle has exemption. Yeah, that is quite normal, right? Every principle has its own exemption. So this is also another principle under the agreement law that we are going to talk, is about consensual principle and freedom of contract principle. But those principles are not without limitation. Yeah, as you can see it here, unless it does not violate public order and decency. Decency is kesusilaan, ya. Public order is ketertiban umum. That's the exact wordings under the Indonesian Civil Code. But also does not violate the law, undang-undang. Yeah. So we are talking about the law in here, not the implementing regulations of the law. Yeah. So that's two different things. There will be time where the legal practitioner will ask whether the violation of implementing regulations of the law will be considered as violating the law or not. Yeah. That is very interesting, and how to answer it more properly, I think we have to see how the judges consider that kind of cases. So complementary law, optional law. So it's an open system. Yeah? Agreement law is an open system. So it is considered as complementary. It's complementary to the agreement that the parties entered into. Yeah. Complementary means that the provisions may be removed when desired by the parties of the agreement. So as you can see in the book 3 of ICC, that is about obligations, right? And there is also a section about sale and purchase, about lease agreement, about borrow and use agreement, and about loan agreement, even employment agreement. There is also a stipulation under Indonesian Civil Code, and also even construction contract, yeah. Kontrak konstruksi, yeah, is also stipulated under the ICC, even though it's very limited. So the point is, they are allowed to make their own provisions that deviate from the articles of the agreement law, from the provisions. They can deviate if the parties desire to do it. If they do not regulate a subject matter, then that subject matter is subject to the law. So there is a just subject matter. Let's say that the agreement that the parties are going to enter is sale and purchase agreement. That's the subject matter. That's the main theme of the agreement, or that's the essence of the agreement. But they don't regulate anything about it. They just agree about the goods to be delivered and the price of sale. That's it. Perhaps the agreement is not made in writing, because it doesn't. Not all agreements must be made in writing. We will also talk about it a little bit. Not all agreements must be made in writing. Like for example, as I said in last week, you have to be more sensitive in doing your activities as human, everyday activities as human being. You go to the supermarket, you go to the mini mart, you buy goods, you buy things, and then you pay for it. That's actually you are doing a sale and purchase contract, right? You are doing a sale and purchase agreement. There is no agreement in writing, but the concept still applies. There is a goods, a thing that you want to buy, and there is also a price to pay. That's the essence of the sale and purchase. And all other things, if they are not regulated, because you don't have an agreement in writing to agree otherwise, because you are allowed, the parties are allowed to deviate, right? That's the complementary law. That's the open system. The parties are allowed to deviate. But if you don't deviate, then you have to follow what has been regulated under the Indonesian Civil Code. So there will be answers if there is a default from one of the parties, there is a breach of contract, or what about the delivery, how the goods is to be delivered. Since the parties don't agree on it or haven't talked about it, then they will follow the Indonesian Civil Code. Of course, this is more related when we are talking from the perspective of the legal practitioners and legal students like us, because normal people never sees Indonesian Civil Code, right? They don't even know, perhaps, most likely, that there is provisions for sale and purchase agreement, for example. There is a provisions for lease agreement under the ICC. What is normally done by the people is just make an agreement, right? They make it in writing without really thinking much about what has been regulated in the Indonesian Civil Code. And that is exactly why the agreement law is an open system. Because that's the freedom of contract. The parties are free to agree on something, and how to do it, that is according to them. So the law gives people freedom, flexibilities as far as possible, with limitations, to agree on something and how to stipulate on that agreement. But of course, in the normal transactions where there is no agreement in writing, we have to, again, if there is a problem, of course, because sometimes, most of the time, there is no problem. The goods is delivered, the price is paid, and it's done. But sometimes there is a problem that the price is only partially paid. What to do then? No agreement in writing. That is the meaning that subject matter is subject to the law, meaning you can refer to the provisions under the Indonesian Civil Code. What will happen if someone breaches the contract? So it will be seen as breach of contract, breach of sale and purchase agreement. What to do about it? Look into the provisions of Indonesian Civil Code. So it's open. You don't need to make it in writing. Yeah. Only some agreements that must be made in writing. Most of it are not. But if there is a problem, you can refer to the provisions. Yeah. So everything is already regulated. Almost everything. Well, not very complete, because the Indonesian Civil Code itself is very old already. But in principle, you can see that most of the human activities have been regulated in ICC actually. Yeah, most of them. Yeah. So no need to worry very much seeing that the ICC is lacking the provisions. Yeah. But maybe on some aspects, some type of agreement, let's say, for example, the lease agreement, well, it's not up to date. Yes, lease agreement. So the lease provisions under the ICC must be updated. And of course, like a construction contract, as I said before, is even more limited than the lease provisions. Yeah. So that is why I think the construction law stipulates, yeah, that the parties having a construction work must sign an agreement in writing, yeah, in writing and in Bahasa Indonesia. So that's stipulated under the law. Yeah, so you have to comply with it. Yeah, and we have language law, Undang-Undang Bahasa, since 2009. Saying and regulating that every individual party, every Indonesian party enter into a transaction for each other, they have to use Indonesian language. If this Indonesian party enter into a transaction with a foreign party, they will also have to use Indonesian language. But for the benefit or for the interest of the foreign party, they can make it a dual language agreement. Yeah, so Indonesian language, and most likely it's an English language. So the foreign party can read and understand also the agreement that they enter into. Okay, let's move forward first. So the open system, which contains the principle of freedom of contract. Yeah, now there is also highly relevant, yeah, between the consensual principle and also the freedom of contract. The consensual principle you can see under the 1320, the first element. 1320. Yeah, there are 4 elements. Yeah, we will discuss this next session actually, but let's look on the first element only. Sepakat mereka yang mengikatkan dirinya. Untuk sahnya suatu perjanjian diperlukan 4 syarat, ya. For the validity of an agreement, 4 conditions are required. First condition is the agreement between them that are bound to it. Ya, sepakat mereka yang mengikatkan dirinya. So that's the consensus. Yeah. Now, if we refer to the 1338, paragraf 1, ya, semua perjanjian yang dibuat secara sah berlaku sebagai undang-undang bagi mereka yang membuatnya. All agreements made legally or made validly or validly made serve as law to those who make them. So the key in here is validly made, ya. Semua perjanjian yang dibuat secara sah, validly made. serve as the law, berlaku sebagai undang-undang. Ya. So the 1338 cannot be detached from the 1320, right? Because the 1338 is talking about the consequence actually of an agreement. But the phrase semua perjanjian, right? Semua perjanjian, all agreements, yeah, is seen as the freedom of contract, yeah, because all types of agreements, as long as those agreements are validly made, yeah, those obligations will be bound, will bind the parties, yeah. So all agreements, semua perjanjian, right? So this is where the freedom of contract principle kicks in, yeah. It stipulates that it is permissible to the people that we are allowed to make agreements that are in the form and contain of anything or about anything, and that the agreement will bind those who make it like a law. Okay. So, semua perjanjian, all agreements, yeah. Freedom of contract. And this is very good actually because agreements between the parties are developing. Yeah. There are so many agreements that are not there when the ICC was made. Joint operation contract, for example. Joint operation contract and build, operate, transfer agreement, right? Those are the things, those are the agreements that are emerged in the modern era, right? I mean, by the development of the law, by the development of the business transaction, then there arises several new types of agreement. But those new agreements also refer to this 1338 and 1320. Yeah. Those new agreements are still an agreement. And as long as an agreement is validly made, they will bind the parties who made them. Yeah, that's the principle. The open system in agreement also contains an understanding that spatial agreements stipulated in the law are only the most popular in society at the time the Indonesian Civil Code was formed. The spatial agreements refer to the named agreements. Yeah, we understand about named agreements and unnamed agreements. Ya, perjanjian bernama, perjanjian tidak bernama. So all agreements that are stipulated under the ICC are called as named agreements, ya, because they put a name into it. Ya. So perjanjian jual beli cannot be said as perjanjian. That's it. Sale and purchase agreement is an agreement, yeah. But when you draft it in writing, it's ridiculous to just put it in the title perjanjian, right? It's confusing. What kind of agreements will this be? Yeah, there is a named agreement. So perjanjian jual beli, you put it perjanjian jual beli, sale and purchase agreement. You must be consistent. Of course, it will be confusing when you write it as agreement. That's it, without this sale and purchase agreement. Or you write it differently as lease agreement, for example, perjanjian sewa. But the contents are perjanjian jual beli, sale and purchase. So it's confusing, and it's not according to the ICC. That's why they divide, yeah. Under the theoretical of law, they divide the named agreement and unnamed agreement. That is based on the ICC itself, because the ICC will stipulate spatial provisions about sale and purchase, yeah, about loan, about a guarantee agreement, about employment agreement, about lease agreements, about, I think those are the things, yeah, borrow and use agreement. That is also stipulated. So the law only regulates the agreements of sale and purchase and lease, but in practice there arises variation of agreement called a leasing. Yes, this is also another concept. Sewa beli, right? If we are talking about lease agreement, we are talking only about sewa, yeah. But then the business transactions are developing, they change a lot, and then there is a leasing agreement, yeah. Even some agreements like confidentiality agreement, yeah, non-competition agreement, yeah, those are a franchise agreement, yeah, those are the agreements that are not regulated in the ICC, but it's there in life, yeah. And those agreements are still referred to the 1338 and 1320, yeah. So there must be a consensus agreement between the parties. That's the consensual principle. And there is a freedom of contract, yeah. And the freedom of contract also says that if the agreement is valid, the agreement will bind. So be careful with this, yeah, because some people will consider agreement as non-binding, yeah. Let's say that he understands that he has an obligation, but he just disregards it. Yeah. He just doesn't care about it, yeah. But why you have to be careful? Because this agreement, if it is made validly, it's binding. And if it is binding, you can enforce it through the court of law, right? You can enforce it. Meaning, if this guy, this man, disregards the executed agreement, he just doesn't care about it. He just doesn't want to do his obligations. And he says that, well, this is only a paper. What do you want to do about it, right? Or he just rip it off, right? Dirobek-robek misalnya, yeah. He just doesn't care about it. Well, we have to understand that under the law, there is an obligation, right? An agreement causes an obligation to rise. And this obligation can be enforced under the law. Yeah, so if he doesn't want to voluntarily comply with it, then you can force it through a court. You can request the court to force him to do it. That's because there is an obligation. That's because there is a perikatan, right? But perikatan can only arise after first that the agreement is valid. So the consensus principle will come first, and then the freedom of contract and its consequence will come afterward. Because that's the legal consequence. After the agreement is validly made, it will bind the parties. Okay, now let's see into the limitations. What are the limitations of 1338? Yeah, this refers to the 1337. Yeah, but actually the 1337 and 1335 are talking about the cause of an agreement. The fourth element of the validity of an agreement under 1320 of ICC. Yeah, if you look again into the 1320, that is the fourth principle, actually, yeah. We are not going to discuss it very deeply today, but we are going to discuss it on the another session about the cause of an agreement, yeah. But you have to see it that the fourth element is suatu sebab yang halal, yeah. A legal cause or a valid cause, yeah, or legitimate cause. The existence of economic or psychological advantage on either party to the agreement allows that one of the parties more dominant in determining the terms of the agreement. For example, standard clause. The ICC does not require a balance between the merits of the two parties to the agreement. However, that does not mean the law gives absolute freedom to the individual. Against freedom of contract applies restrictions as prohibited by laws, ethics, decency, and public order. So if we look into 1337, suatu sebab adalah terlarang. A cause is forbidden apabila dilarang oleh undang-undang, if against the law, if prohibited by law, atau apabila berlawanan dengan kesusilaan baik, or if violated with decency, atau ketertiban umum, or public order. But 1337 is talking about the cause, right? Suatu sebab. And if we look into the fourth element of 1320 is suatu sebab yang halal. So if it is a forbidden cause, it is not a halal cause, right? I repeat, if it is a forbidden cause, it is not a halal cause, or it is not a legal cause or legitimate cause. Yeah. So it's not really talking about the limitations of freedom of contract. That's my point. Yeah, because the freedom of contract is under 1338. But the 1337 is actually talking about the cause. Yeah, it's a different concept. We will talk about each element of the validity of contract in the next session. But that is quite common now. Yeah, I mean, it's by the legal practitioners, by the legal experts. They most likely will refer to the 1337 when saying that this agreement is violating the law, public order, or ethics. Yeah. In the first point, we see that about the standard clause. Yeah, I will briefly explain this. You realize that in a business transaction, there is a standard agreement, Perjanjian baku. Yeah, we call it as Perjanjian baku, standard agreement, which contains klausula baku, standard clause. Yeah, so standard agreement, standard clause. For example, if you want to buy a property, they will just show you the agreement. They don't want to discuss about the contents. They don't want to renegotiate the contents. Yeah, they just give it to you and ask you to sign it. That's the standard agreement. And the standard clauses are the clauses contained in the standard agreement because it's standardized. Yeah, but not all standard clauses are considered as violating the law. And it's always happening in many other transactions, such as loan agreement with the bank. If you go to the bank and asking a loan, they will give you also the standard loan agreement, right? And now it's online, everyone is using apps. Now there is a financial technology company giving small loans through apps, only apps, right? So you just click this, click that, and when you click, you agree to the terms and conditions. That's everything is standard, right? The terms and conditions are standardized. There is no room for negotiation. There is no room for negotiation. So if you don't like the terms and conditions, you just have to withdraw from it. Yeah. But if you click it and you agree to it, then it will be seen that as an agreement. You are voluntarily agreeing to the terms and conditions. Nobody is forcing you. Nobody is putting a gun against you and pointing a gun against you. Nobody is physically force you to do it, right? Physically force your pointing finger to click it. So that's interesting to consider, because that everything of related to that will relate to the freedom of contract principle and also consensual principle. And the ICC, the Indonesian Civil Code, does not require a balance. So balance means that it doesn't have to be a balance between the creditor and the debtor. That the creditor gives something and in vice versa, or in return, the debtor will give a balanced performance. It's not like that. This is an opinion of J. Satrio. Yeah, J. Satrio, you can look from his book that I outlined before ya in the first session, hukum perikatan yang lahir dari perjanjian, and also hukum perikatan. You can look and read his opinion about it. But this is kind of an old concept, yeah. Does not require a balance. But this is a important principle to understand, because this is also the fundamental principle of freedom of contract, actually. It does not require a balance. It doesn't have to be a balanced performance between the parties. Because if it is seen as a balance, there must be a balance, perhaps the standard agreement and the standard clauses can never work very well. Now, when we are talking about standard clauses, I don't know whether you understand. You understand about the consumer protection law, right? You at least you have heard about it, ya. Undang-Undang Perlindungan Konsumen. Under the consumer protection law, there is a stipulation of standard clauses and standard agreement. Consumer protection law, right? So there is a provision under the consumer protection law, Article 18, if I'm not mistaken, stipulating the standard clauses that are violating the law, that are considered as a bad clauses. You cannot insert those kind of standard clauses in the agreement. If you insert those kind of clauses in the agreement, that clause will be considered as null and void. Yeah, null and void. Only that clause, not the whole agreement. So you have to see that when the legal cause is breached, the legal cause of an agreement, the cause is not legal, the cause is not halal, the cause is not legitimate, that will be considered as null and void. But when there is a sell and purchase agreement, for example, and sell and purchase of property, for example, like an apartment, is not prohibited under the law, right? The law allows it. So the cause is halal, the cause is legal, right? But when the sell and purchase agreement for the apartment has or contains standard clauses, that will be considered as violation of consumer protection law, and that clause will be considered as null and void. Well, the law, the consumer protection law actually does not say that the null and void will only occur when the court says so. No, right? It doesn't state that like that. The same concept applies for the violation of cause. If you do a sale and purchase of drugs, for example, that is prohibited under the law, that sale and purchase is null and void immediately without any questions, right? I think it's ridiculous to go to the court just to cancel a sale and purchase of narcotics, for example. Why do I need to do that, right? But in a standard clauses example, it will be different, yeah, because it's there will be debate whether or not it is considered a standard clause violating the consumer protection law. And if it is not, then it is binding, right? Because the contents of an agreement are binding to the parties. So that's why I think even though the concept is null and void, the standard clause violating the consumer protection law must be considered as null and void. But in practice, it's always requested through a court. And guess what? Most of the time, the court says that you have read it beforehand and you have agreed to those terms. So this is a freedom of contract principle. You are bound to it. Yeah. So most of the time, the courts say that. We will look into it when we discuss the cases, but today's cases is not really heavily related to the consumer protection law, but to the freedom of contract principle. But I think there is one that is related to it. So it's interesting, yeah. So again, these are the limitation actually of the freedom of contract principle, that the standard clauses violating the consumer protection law are not allowed to be inserted. If it is inserted, it will be considered as null and void. The clause only, yeah, not everything. And also Satrio says that does not require a balance. So that's why the performance of one party and the other party doesn't need to be balanced. Okay, that's, I think, important to understand. But the balance principle in here is not without limitation also. Yeah, so again, one principle, there is most likely an exemption of that principle. So the balance principle, even though you don't need to agree balanced performance between the parties and stipulate it under the agreement, it doesn't mean that it is without limitation. For example, in an agreement between the parties where the agreement says that everything will have to be according to the one party's valuation and judgment, and anything at all that one of the parties regards as not good, yeah, based on his judgment, he can terminate the contract. Anything that he dislikes during an agreement, he can terminate. That is too much, right? So if, let's say, this person really do terminate the contract because there is something happening during an agreement that he dislikes, that it is proven that what he dislikes is not important at all, yeah, that is violating the balance principle actually. It is not balanced. Even though we agree, we understand that the performance doesn't have to be balanced, but it does not mean that you can terminate the agreement anytime you like, with whatever reasons that you bring into. It's not okay. There is a legal expert, I think it's Herlin Budiono, I think, yeah. She writes a good books. Yeah, she writes, I think, several good books. She is a lecturer in University of, I forgot, Pajajaran or Parahyangan, and she is a notary, yeah. So she wrote several good books, I think, and about the principle the balance principle. And from her research, she concludes that if you terminate an agreement without a valid reason, without a legitimate reason, so if you want to terminate an agreement, there must be a valid reason, a legitimate reason. It cannot be done with just how to say, remeh-temeh gitu loh. It's hard to say it in English, I don't know. Remeh-temeh is tiny reason, unimportant, highly unimportant reasons, remeh-temeh. Jadi if you terminate with a reason that is remeh-temeh, it's violating the balance principle. So that is also the limitation of balance principle. Okay, so you see that even though we have a freedom of contract principle, we also have limitation of freedom of contract. And we discuss about standard clause, we discuss about a balance principle, but there is also limitation. There is I once read a dissertation that becomes a book from a good lawyer, famous in the consumer protection law. He said that the consumer protection law actually is not really effective, because you have to go to the court to enforce it. And most of the time, most cases are not gone to the court, right? Are not brought to the court. So he desperately said that the judge should have stated in the decision that this decision is not only applicable for the disputed parties, tidak hanya berlaku untuk para pihak yang bersengketa, but also for the public. Well, I think, of course, it's a violation of disputing. I think it's a violation of civil procedural law, hukum acara perdata, and it will also be not effective from my view, because the law is there already. The consumer protection law is there. Now the judge declares publicly that this has to be done by all. I think will be the same, right? The law already there. The law is for public, and then there is another decision addressed to the public. I think it will be the same. The effect will be the same. Non-effective will be the same. Again, why is it not effective? I think because the freedom of contract principle. The parties are always trying to agree what is comfortable between them. They don't want to pursue something that is not comfortable. Well, the consumer protection law makes them uncomfortable, right? Makes some aspects are not comfortable to do with. Okay, consensual principle. Though this word is from the Latin consensus. Consensus kan, we know it. Consensus, agreement kan, kesepakatan, persetujuan, consensus. An agreement is also called a consent, persetujuan, meaning that two parties have agreed on something. I think Professor Subekti is more on persetujuan than perjanjian actually. No, I think he's saying more on the agreement, not really on the persetujuan. But sepakat, right? That the first element we see is sepakat, so consensus, and there will be a defective consensus, atau kita sebut sebagai cacat kehendak, defective consensus, defective will of the parties. That's another thing. We're not talking about it today. The meaning of the word consensus, consensual, is basically the agreements and obligations that arise, hence it has been born from the moment the consent is reached. Kesepakatan dan kecakapan, right? When the consensus occurs, the consensus is reached, the consensus takes place, then the agreement actually is done. Yeah. Of course, there will be obligation after that. Yeah. The agreement is valid when it has been agreed on the main matters and no formalities are needed. Formalities, for example, like you don't have to make it in writing, right? You don't have to make it before the notary. You don't have to notarize it. Yeah. That's the principle. But of course, there are exemptions. Agreeing is actually a meeting between two wills, two minds, yeah, where the will of one person fills each other with what the other wants. Wills itu maksud saya kehendak, ya, kehendak. So there is a kehendak, yeah. I think it's a similar concept with mens rea, ya, kehendak. When you want to do a criminal act, you must will it first, right? Kamu memang berkehendak untuk melakukan kejahatan. You have the motive. Now, also the same as agreements, yeah. When the parties enter into an agreement, there should be a motive. There should be a will between them to enter. I mean, that's the intention of the parties, right? The agreement cannot just happen without a motive, without a will, and this must be two wills. Ya, perjanjian ada yang sepihak, ada yang tim. Of course, most of the perjanjian kan timbal balik, are reciprocal, but there is also a unilateral agreement. Yeah, where unilateral agreement is, well, it's not much, right? It's a grant, hibah, that's it. But reciprocal agreement is the common concept that we are discussing. So there has to be two persons at least, two parties, two minds, two wills to enter into an agreement. So it doesn't happen automatically, right? An agreement can only rise when the people, two persons, two parties, are willingly taking part into that agreement. So it's intentional. Meeting of minds, they said it. Yeah, they said it also as a meeting of minds. So two minds are met, meeting of minds. That is the consensus actually. When it is reached, when it is met, then the agreement is actually concluded. Well, it's not just like that, right? Because it's only the first element. We have to see the second element, the third element, the fourth element. But mainly it is the thing. Mainly that's the criterion that you can use, yeah, whether there are meeting of minds or not. And there is also a legal case that I will show, but next session, not this session, about the problem of meeting of minds. It's very interesting, yeah, because one party says there is no agreement yet, and the other party said, of course there was an agreement already, and you are bound to it, yeah. So the court case is about the debate between that thing. One is arguing that there was an agreement. The other argues that the agreement is not reached yet. We are still negotiating. So how to look into it is very interesting. Yeah. So when further examined, the core of the agreement is an offer received by the opposing party in the agreement. Offer and acceptance can come from both parties reciprocally. Okay, there is no concept of offer and acceptance in the ICC. We don't look into it, right? We cannot find it. But of course, in the theoretical concept of law, J. Satrio talks about it, and I believe Professor Subekti talks about it, even though Professor Subekti talks very briefly. If you want to study the offer and acceptance concept, you have to look into J. Satrio book, yeah, because he's the one, I think, who is really digging deeply into that matter. offer and acceptance. And it's always like that, right? There is an offer. If you watch your YouTube, there is always an ad promoting this and that. And then when you click on that ad, they will bring you to a page with an offer. Yeah, if you buy this today, you will receive a discount, 20% discount, for example. That's an offer, right? The offer from the seller. And when you agree to it, when you accept it, you click into it. Yeah, because you click into it, then you accept it. That's in the simple form. But if we are talking about construction contract, for example, it's not simple, right? It's actually not simple at all. It's very complicated. So there is an offer from the project owner or from the service user to the service provider. Can you construct a building for our interest? I will give you so much money for that, right? And then the contractor will also give a counter offer. Yeah, maybe the pricing, he would like to adjust the pricing from 100 to 120, for example. The time frame is stipulated for 1 year, but he said 1 year is too less, and request for 1.5 years, for example, 1.5 years. So that is the over, counter over lagi, until it's accepted. When it is accepted, that's the meetings of mind. That's the consensus is happening. Yeah, that example is for not simple consensus. Yeah, but of course, in our daily lives, going to the mini mart, going to wherever there is easy and daily life, it's simple, right? It should be simple. It's not much talking about offer and acceptance. Yeah. So we just agree with it and go for it. Offer is interpreted as a proposal to close the agreement addressed to the opposing party, to the other party. Yeah, it's not opposing party, to the other party. The proposal has been formulated in such a way that the acceptance of the proposal directly gives rise to the agreement. Me, as a lawyer, has a law firm. From time to time, of course, I will give a proposal to my client. When I prepare the proposal, sometimes they will just sign it. Yeah, they will just sign it and return the proposal to me. So it's binding already. It's an agreement. But sometimes also they would like to have a clarification on something. Or they said that, can we revise this section? Can we revise this part? That's the counter. Yeah, over and then counter over. Yeah, that is the counter. So those interactions are over, counter over, counter over, counter over. Yeah? Until it is accepted, that is the process of negotiation. Yeah. So sometimes they sign it immediately. Sometimes they request for a revision, and then I have to revise it, the offer, and then resend it to them. And then after that, after it is revised, they agree, they are happy with it, they will sign it. That's become an agreement. That's binding. And it's all related to the consensus principle. Okay, there is an exception to the principle of consensual. Yeah, by law, certain formalities are established for some kinds of agreement. If the provisions are not fulfilled, then the agreement will be void. Yeah, for example, like hibah for immovable goods I think also for movable goods. Yeah, no, not for movable goods. For immovable goods, we have to go to the PPAT, ya, Land Conveyancing Officer, pejabat pembuat akta tanah. It must be made in writing. And actually, for all transactions related to the registered land in Indonesia, will have to be made in standard form, right? Akte jual beli, hak milik misalnya, akte tukar menukar, akte pemasukan dalam perseroan inbank. You inject or you put into company your own lands in bank. There must be made in PPAT, deed of PPAT in writing, made before PPAT with a standard form and everything. For example, like construction contract, I said earlier, it must be made in writing, it must be made in Bahasa Indonesia. That's very specific under the construction law. And based on language law, then all agreements must be made in Indonesian language. If you enter an agreement with a foreign party, you can use dual language. You don't have to do it, actually. It's an option. But of course, most of the time it will be translated or executed in dual language. And for example, like settlement agreement, perjanjian perdamaian, must be made in writing. Settlement agreement must be made in writing. It cannot be made just verbally. Yeah. So that is the formal requirements that we have to understand. Yeah. We have to understand. Because if it is not followed, then it can be considered as null and void. Nah, this is the one. You can refer to the 1851. Perdamaian adalah suatu perjanjian dengan mana kedua belah pihak dengan menyerahkan, menjanjikan, atau menahan suatu barang, mengakhiri suatu perkara yang sedang bergantung, ataupun mencegah timbulnya suatu perkara. Perjanjian ini tidaklah sah, melainkan jika dibuat secara tertulis. So, we understand that there is 1320, right? The elements of validity of a contract. There are 4 requirements, right? 4 elements. But in here, in 1851 states that it's not enough. 1320 is not enough. Plus, made in writing. So 1320 is fine. You have to fulfill it. Plus, made in writing. So that is the formal requirement. If it is not made in writing, perjanjian tidak sah, he said. Yeah, ICC said. Perjanjian tidak sah. So, if it is not sah, it is not an agreement, right? You cannot enforce it. You cannot enforce it. If it is not enforceable, well, it's no point to have a settlement agreement, right? It is not enforceable. If the other party defaults again, breaches again, you cannot enforce it. So that is the thing that we have to bear in mind. And I believe there are some other types of agreement, yeah, like franchise agreement. If I'm not mistaken, it's also must be made in writing. Franchise agreement, but employment agreement, maybe not. Yeah, employment agreement. It doesn't have to be made in writing. It will be developed, yeah. I mean, there will be other types of agreement that must be made in writing. For example, if we look into state-owned assets, barang milik negara, or local government-owned asset, barang milik daerah, they also have a concept such as a cooperation with the third party, right? So the government, the central government and the local government can cooperate with the third party to utilize their assets, state-owned assets or regional-owned assets. But they have to follow the requirements under the agreement, because for example, they can do a build, operate, and transfer agreement, BOT, bangun guna serah, They can also lease the asset out to the third party. They also can even borrow and use it to the other party. But there are requirements. When you do it, then the agreement must be made in writing. That's number one. Number two is must be made in notarial deed, so it must be notarized. And number three is even the regulation itself stipulates what are the minimum contents of the agreement. So see, again, those are the formalities regulated under the regulation. We, as legal practitioners, legal students, legal researchers, will have to look into it. We cannot disregard it because there are formal requirements of the contract and there are material requirements, right? The substance of the contract. Whether the formal requirements can prevail over the material requirements. If the formalities are not met, then the agreement is not valid under the law. If the agreement is not valid under the law, the agreement is non-binding. If the agreement is non-binding, meaning there is no agreement at all, so you cannot enforce your right under the agreement. So that is, I think, will be developing. The ICC only talks about grant, hibah, and also the settlement agreement that must be made in writing. Even lease agreement, they don't regulate that it must be made in writing. But now, under the housing law and condominium law, we can find that a lease agreement for that kind of property must be made in writing. Harus dibuat tertulis. So it's developing. The formalities are developing. So we have to follow the trend. We have to understand the legal update. So we are not left behind. Okay, I think I have explained about the open system. Why is it open? What contrasted to the law of property? I've talked about consensus principle. I have talked about freedom of contract principle. Whether 1338 cannot be detached from the 1320. Especially the consensus, the first element of the 1320. So they are interrelated. The consensus and the freedom of contract principle. But principles are not without exceptions. Principles are most likely with exceptions. And these exceptions, even though it is not really regulated as limitations of principle of freedom of contract, but the legal practitioners, legal experts always refer to the 1337. You can make all agreements as long as you don't violate the law, the decency or the ethics, or the public order. But the limitations of freedom of contract, as we see before, and also the consensus principle, is not only about that three principles, right? The three limitations, because we also have limitation on formalities. The formalities must be met. We also have limitations in consumer protection law, for example. Those are also limitations. But that limitation only applies between consumer and seller, actually. If you are, and it only applies to an individual consumer. If you are not an individual, you are not considered as consumer actually under that law. Yeah. So even though there is an exemption, but there is also limitation on that exemption. Yeah. So the company is not considered as consumer, because most likely a company will buy things and then to use that thing or to use that good for its business transactions again, right? So it cannot be considered as consumer. So those are those are the consensus principle, freedom of contract principle, and also the limitations.